Officer Derek Mason sat in his patrol cruiser on Peachtree Road in Atlanta, hands steady on the wheel, eyes hidden behind mirrored sunglasses that reflected nothing of what he was thinking. He'd been on the force for 12 years. 12 years of knowing exactly how things worked, and more importantly, knowing exactly how to work the system. His personnel file told a story that nobody had looked at carefully enough. 9 racial profiling complaints in 6 years. 9 times someone had filed a complaint saying they'd been stopped without cause, harassed based on the color of their skin, subjected to searches that had no legal justification. 9 times the complaint had been processed, reviewed, and quietly dismissed. The reasons varied on the paperwork: procedural technicality, insufficient evidence, officer statement contradicts complainant account, investigation inconclusive. What the file didn't say, what the statistics didn't reveal at first glance, was that Mason had conducted 847 traffic stops in those same 6 years. When you divided it down, when you actually looked at the numbers instead of just filing them away, the pattern became impossible to ignore. In a jurisdiction that was 22% black and 8% Hispanic, Mason's stops were 67% black and 18% Hispanic. The numbers didn't lie, but they were easy to ignore if you weren't looking for them. Mason believed the uniform made him untouchable. The system had spent 6 years proving him right. He was cruising without purpose that Tuesday afternoon, just looking. That was the word he used in his mind. Looking. Not hunting, though that's what it was. Looking. As if he were simply observing the landscape, paying attention to his surroundings, doing what a good cop did. His radio crackled with routine dispatch calls. A shoplifter at the strip mall on Peachtree. A noise complaint 2 neighborhoods over. Nothing urgent. Nothing that required his attention. But Mason wasn't interested in urgent calls. Urgent calls meant real crime, and real crime was unpredictable. He preferred something he could control. That's when he saw the Mercedes. The car was black pristine with dark tinted windows that suggested someone who wanted privacy. The driver was a black man. Mason didn't need to think about why that mattered to him. In his mind, it simply did. The car was expensive. The neighborhood was Buckhead. The math was simple. He noticed the vanity plate, JUDG-MRC. He didn't read it correctly. His mind filled in what it expected, what fit the narrative he was already constructing. A black man in a luxury car in a white neighborhood. That was the story his brain told, the story his experience had taught him to tell. Mason accelerated, moving 3 cars back, positioning himself to follow. This was the hunt beginning, though he would never call it that. It was patrol work. It was observation. It was doing the job. He'd spent 12 years refining this skill, and he was exceptionally good at it. The Mercedes was doing exactly 35 in a 35-mile-per-hour zone. Perfect. It wouldn't matter. That was the beautiful part of how Mason worked. The traffic violation was just a starting point. If the driver was going 35 in a 35, he'd find something else. Unsafe lane change, failure to signal a turn that was technically 3 feet too late. Tinted windows that might have been slightly darker than legal. There was always something. The system had taught him that. The system had taught him that rules existed for him to deploy as he saw fit. 4 minutes later, the Mercedes turned onto a residential street leading deeper into Buckhead. The traffic was lighter here. Trees hung overhead, creating a canopy of shade over streets where homes were set back from the road, where property values climbed with each block, where neighbors expected a certain kind of peace. This was where he wouldn't belong, the place where people would notice him, the place where the rules were supposed to matter. Judge Marcus Richardson was driving on autopilot the way you drive a route you've traveled thousands of times. 62 years old. Federal judge for the last 23 years. 13 years before that as a prosecutor specializing in civil rights violations. His career had been built on understanding power, how it was used, how it was abused, how it was protected by systems that preferred to look away. He'd convicted 47 police officers for misconduct. 47. The number lived in his mind not as a source of pride, but as a reminder of the endless nature of the work. For every 47 officers convicted, there were hundreds more doing exactly what those 47 had done, protected by departments that chose not to see, by unions that prioritized protection over accountability, by systems that moved slowly enough to wear down victims until they gave up. That Tuesday afternoon, Richardson was thinking about Thursday's docket. Federal court didn't stop for anyone. Cases awaited him, decisions needed to be made. Justice required someone to be paying attention. He'd driven this route from downtown Atlanta to his neighborhood in Buckhead thousands of times. Same turns, same traffic lights, same trees shading the same streets. It was routine enough that he could think about other things while his hands guided the wheel. He'd accepted his physical limitations a decade ago when his legs stopped working the way they were supposed to. He'd adapted, moved to a neighborhood he could navigate, built a life that made sense within the constraints of his new reality. It was a good life, quiet, orderly, safe. At least it was supposed to be safe. He was on Elm Street when he noticed the police cruiser behind him. At first, it was just something in his rearview mirror, another car, another part of the traffic pattern. But he'd spent enough years prosecuting cases to recognize when something shifted, when a simple presence became focused attention. The blue lights came on suddenly. Flash, flash, flash. The rhythm was aggressive, almost taunting. Richardson checked his speed, 35. Not 36, not 34. He scanned backward through the last few minutes, through the turns he'd made, through the lanes he'd occupied. Everything had been careful. Everything had been correct. He'd been in the same lane for 2 miles. The officer was approaching quickly, hand resting on his service weapon. The sunglasses were mirrored reflective, designed to hide rather than reveal. Richardson recognized the posture immediately. He'd seen it in 1,000 courtroom testimonies from people who'd been through this exact moment. The confidence of someone who believed the uniform made him invulnerable. Richardson pulled into a nearby residential driveway and stopped. Not abruptly, carefully, hands visible on the steering wheel, the trained response of someone who understood that compliance was survival, but also someone who understood that this moment, this interaction was being documented in ways both visible and invisible. Officer Derek Mason took his time approaching, deliberately slow, deliberately aggressive in his slowness, as if each step was meant to demonstrate his control of the situation. His hand remained on his weapon. His sunglasses reflected the sky, the clouds, the afternoon light, but nothing of his expression. He gestured for the window to come down. Richardson lowered it. License and registration. Now. The tone wasn't a request. It wasn't a question. It was a command, the kind of command that only worked if the person receiving it accepted the authority behind it. Mason had learned this over 12 years. Tone mattered more than words. Certainty mattered more than justification. Officer, I wasn't speeding. My registration is current. May I ask what I've done? Richardson's voice was calm, measured the voice of someone trained to speak in courtrooms where every word mattered. But tone alone wouldn't save him. He already knew that. Mason's jaw tightened. The question itself seemed to offend him, as if Richardson was challenging his authority simply by asking for an explanation. You were weaving between lanes. It was a lie. It was immediate, automatic, delivered with the confidence of someone who'd lied to police reports 100 times before. Richardson had heard this lie in courtrooms. He'd convicted officers on this lie. He recognized it instantly. Officer, I've been in the same lane for 2 miles. There are witnesses on this street. Are you seriously going to tell me how to do my job? Richardson heard the escalation in Mason's voice. He heard the anger that had nothing to do with traffic safety and everything to do with the color of Richardson's skin sitting behind the wheel of an expensive car in a neighborhood where that combination was considered wrong. Richardson had spent his career studying this moment, understanding it, recognizing the precise instant when an officer's bias turned into a threat. He made a choice. The choice to stop arguing. The choice to let this moment play out, to let the officer reveal himself, to let the situation develop in a way that couldn't be ignored. Mason's hand moved. Not to his ticket book, to his radio. "Dispatch, this is Unit 12. I need backup on Peachtree. Got a potentially hostile 1015 refusing to comply." The words hung in the air between them. Potentially hostile. 1015. Refusing to comply. Richardson had heard these terms in courtrooms translated by officers into justifications for what came next. He understood what Mason had just done. He'd created a narrative. He'd told a story that transformed a calm, compliant man into a threat. He'd engineered the next level of escalation. "Step out of the vehicle. Now." Richardson complied immediately, slowly, hands visible, the trained response of a man who understood that every moment was being judged, every action interpreted through the lens of bias that had already decided what it would see. Mason positioned him against the Mercedes' spread-eagle legs, uncomfortably wide, arms extended at an angle that would be difficult to maintain. It was a position of vulnerability, of exposure, of physical dominance. The message was clear. "I have the power here." A young officer stepped out of the cruiser. 29 years old, maybe 30. His name was Edwards. He'd graduated from the academy maybe 6 months ago. He still believed that training mattered, that rules meant something, that there was a difference between right and wrong. He watched Mason's hands on Richardson's suit jacket, watched the rough movements, watched the complete absence of courtesy or concern for the man he was searching. "You got any weapons on you?" "No, sir." "You carrying drugs? Anything illegal?" "No, sir." On the street, on the porches of the homes set back from the road, lights were coming on. Neighbors were emerging. A woman across the street had her phone out. She'd seen many things in her 15 years living in this neighborhood, but she'd never seen 3 police units converging on a single car. She'd never seen an elderly black man being spread-eagled against his own vehicle. She started recording. A second cruiser arrived. Then a third. 3 police units. For one man in a business suit who had committed no crime. For one man in a neighborhood where this kind of police presence was unusual, where the appearance of force was itself a kind of message. Mason's demeanor shifted slightly with the arrival of other officers. He became more aware of the cameras on their cruisers, of the phones in neighborhood hands, of the fact that this moment was being documented from multiple angles. But he didn't back down. "Your registration is coming back suspended. You need to explain that." It was another lie. Richardson's registration was current. He'd renewed it online 3 weeks ago. The confirmation email was on his phone. But he also understood something fundamental about this moment. He couldn't win through argument. He couldn't prove his innocence by accessing his documents because Mason wouldn't allow him to access them. He couldn't explain without being accused of arguing. The trap was perfect. Mason had positioned him where compliance was impossible. Officer Edwards stepped closer to Mason. The younger officer had felt something shift. "Derek, what'd we stop him for?" The question was simple. The question was dangerous. The question was the moment when the narrative that Mason had constructed began to crack. Mason hesitated. Just for a second. Traffic violation, unsafe lane change, and his registration is suspended. Edwards looked at Richardson, then at the Mercedes, then at the neighborhood, then at the man standing spread-eagle against the car in a business suit that cost more than Edwards made in a month. The young officer did the calculation. This man didn't fit the profile of someone with a suspended registration. His vehicle was immaculate. His hands were manicured. His bearing was calm, despite the physical violation occurring against his body. "Can I see the dash cam footage of the lane change?" Mason's response was immediate. didn't turn it on yet. The silence that followed wasn't empty. It was full of understanding. It was the sound of everyone present understanding that the narrative had just failed. It was the moment when the official story stopped matching the observable truth. Judge Marcus Richardson, at that moment, made a decision based on 23 years of sitting on the federal bench. He understood when a narrative cracked. He understood when the moment was right. He understood that the power dynamic was about to shift. Officer Mason, I need to tell you something. You need to shut up and wait for your citation. I'm a federal judge, U.S. District Court for the Northern District of Georgia. My name is Marcus Richardson. Judge Marcus Richardson. The world seemed to stop for a moment. The blue lights from the police cruisers continued their rhythmic flashing. The evening was still warm. The neighbors continued their recording. But everything had changed. Mason's face went pale, literally pale. The color drained from his features as his mind made the connection. Judge Marcus Richardson, the same judge who had convicted Officer Thomas Garrett for civil rights violations. The same judge who had convicted Officer James Chen for racial profiling. The same judge whose courtroom was feared throughout Georgia law enforcement precisely because he had no patience for abuse of power, no sympathy for officers who hid behind their badges. Officer Edwards took a step back. He understood what was happening. He understood that his training officer had just stopped someone who had the power to destroy him. The neighbors on their porches held their phones steady. At least 3 people were recording. At least 3 people had documented the moment when authority realized it had made a fatal mistake. The pause that followed the identity revelation was profound. It was the kind of pause where understanding arrived not through words, but through the sudden crushing realization of what had just been done and what it would mean. Mason's hand dropped from his service weapon. Not slowly, not with dignity. It dropped like he'd forgotten it was there, like his body was responding to something his mind was only beginning to process. Judge Richardson Edwards said quietly. The title came naturally to him. It was a reminder of who held actual authority in this moment. I apologize. But Mason didn't apologize. Couldn't apologize. His jaw was working like he was trying to form words that wouldn't come. His mind was running through calculations that led nowhere good. 12 years of career, 9 previous complaints, 847 stops conducted with this same approach, this same lack of justification. And standing in front of him was a federal judge who had spent his career prosecuting officers who did exactly what Mason had just done. Richardson remained composed. He understood the magnitude of the moment. He understood that his safety was no longer in question, that the threat had shifted from physical danger to institutional consequence. Officer Mason, you can lower your weapon. I'm going to lower my arms now, and I'm going to turn around. I'm not a threat. Richardson moved slowly, deliberately, his hands always visible, his movements controlled. He turned to face Mason and the officers. His suit was dusty from the car. His dignity remained intact. Judge Richardson Edwards said, "We're very sorry. This was a mistake." "This was not a mistake," Richardson said, his voice level and clear. "This was a choice. Officer Mason chose to pull me over. Officer Mason chose to assume I was dangerous based on the color of my skin. Officer Mason chose to call backup and escalate a routine stop into a show of force. Those were all choices. A 4th police cruiser was arriving at the scene. This one carried Lieutenant Sarah Chen, who supervised the Traffic Enforcement Division. She'd received a call about a situation on Peachtree. She'd received a call telling her that Officer Derek Mason had just initiated a stop on a federal judge. As she emerged from her cruiser, she understood immediately what she was looking at. Her face changed when she made the connection. "Judge Richardson," she said, approaching carefully. "I'm Lieutenant Chen. This was absolutely inappropriate. We will be opening a full investigation immediately." Richardson nodded. He'd expected nothing less. The institutional response was almost automatic at this point. but he also understood something fundamental about what had just happened. He understood that while his identity had protected him, while his position had stopped the escalation, there were countless others for whom this moment had no identity to reveal, no professional standing to fall back on, no badge of federal authority to shock the system into recognizing its own failure. "I appreciate that," Richardson said. "But I want to be very clear about what happened here. If the man in this driveway had been someone without the knowledge I have about the law, without the resources I have to fight back, without a network of people to call, without a federal judge's standing to demand accountability, if he had simply been an ordinary black man in an expensive car in a white neighborhood, this could have ended very differently." The words hung in the Atlanta heat. Lieutenant Chen nodded. She understood. "Officer Mason, I'm suspending your badge effective immediately. You are on paid administrative leave pending a full investigation by Internal Affairs and the FBI." Mason opened his mouth. He closed it. He understood the game was over. Richardson didn't demand apologies. He didn't threaten lawsuits, though they were undoubtedly warranted. He understood something that only comes from sitting on the bench for 2 decades. The power of patience. The power of restraint. The power of making the other party understand what they had done without needing to scream about it. "I'll need copies of all dash cam footage, body camera footage, dispatch recordings, and Officer Mason's complete personnel file," Richardson said quietly. "Of course, Your Honor," Chen said, and the title came naturally, a reminder of who was actually in authority in this moment. It wasn't Mason. It wasn't Chen. It was Richardson. The man whose rights had been violated, whose authority had been questioned, whose identity had transformed him from victim to judge. Richardson retrieved his license and registration from his car, finally allowed to do so. And he looked at the scene around him. The neighbors on their porches, the police cruisers with their lights still flashing, the officers understanding that something had fundamentally shifted, the recording devices capturing everything. He turned to Edwards before leaving. "Thank you for questioning that narrative," Richardson said. "That's the job. That's exactly the job." Edwards nodded, understanding the weight of what had just been acknowledged. He'd been trained to follow orders. He'd been taught that his training officer knew best. But in this moment, he'd chosen to see the truth instead of the narrative. It was a small act. It would cost him. What happened over the following weeks was not a gradual unfolding. It was a cascade. It was a system that had been designed to protect itself, suddenly forced to confront what it had been protecting. Within hours of Richardson's identity being revealed, Internal Affairs opened Mason's complete file. What they found had been in plain sight all along. 9 complaints of racial profiling spanning 6 years, all dismissed, all protected by a system that functioned through procedures and technicalities. But when those procedures and technicalities were suddenly under federal scrutiny, when a federal judge was asking questions, the picture became impossible to ignore. 847 traffic stops in 6 years. When the data was sorted by race and neighborhood, the pattern that emerged was so stark that it could not be explained by legitimate police work. 67% of those stops involved black drivers in neighborhoods that were only 22% black. The statistical impossibility of coincidence became mathematical certainty of targeting. But statistics don't convict officers. Stories do. People do. Evidence does. Detective Sarah Wright, who worked in the police department's detective division, began pulling records. She found text messages between Mason and other officers. The messages had been sent months before Richardson's stop, but they existed in digital records that had previously been ignored or overlooked. Texts suggesting neighborhoods where stops were easy pickings because certain people didn't know their rights. Texts discussing how to get ahead on numbers through traffic stops that would generate citations. Texts using hunting metaphors describing black drivers in expensive cars as good hunting ground. The language was casual and predatory. It revealed the actual thinking behind the stops, the actual motivation. It wasn't about police safety. It was about numbers, about enforcement targets, about treating certain neighborhoods as if they were hunting territories, and the people who drove through them as prey. By Tuesday evening, the Georgia Bureau of Investigation had been notified. By Wednesday morning, the FBI was involved. By Wednesday afternoon, news vans were positioning themselves outside the police department building. By Thursday morning, it was national news. The Washington Post ran a headline that was almost too simple. Federal judge pulled over in his own neighborhood. Investigation reveals pattern of racial profiling by officer. CNN did a different angle. Black federal judge's traffic stop exposes broader pattern. The New York Times approached it analytically. Georgia police officer suspended after stop of federal judge. Investigation reveals significant bias in traffic enforcement data. But it was The Guardian that understood what had actually happened. Their headline was different. Not about the judge. Why the real issue is deeper than one traffic stop. Because that was the truth. Richardson understood this. The media was beginning to understand this. The nation was understanding this. One federal judge might not have been stopped if he weren't a judge, might not have been immediately protected if he weren't a person of power. But 846 other people had been stopped by the same officer without judge's identity to protect them, without federal credentials to shock the system into action. Richardson released a statement through his chambers. His words were careful and measured. This incident reflects broader issues that extend far beyond one officer or one department. I am grateful that I have the knowledge and resources to understand what happened to me and why it happened. Most people do not have those advantages. My interest is not in personal vindication, but in using this moment to expose the patterns that affect communities every day. The attention focused on this incident should be focused on the 846 other people who experienced similar treatment, but had no platform to demand accountability. The media cycle shifted. The story wasn't just about a judge anymore. It was about everyone the judge represented. Everyone whose traffic stop went unrecorded, everyone whose complaint was dismissed, everyone whose experience didn't matter, because they lacked the standing to make it matter. Police union lawyers immediately filed motions to dismiss charges that hadn't even been filed yet. Their argument was preemptive and clear. Protect your own before the federal system takes action. But the more they fought, the more transparent their resistance became. The union was fighting for Mason not because he was innocent, but because he represented the system itself. If the system could protect Mason, it could protect anyone. Chief of Police David Patterson held a press conference. He was in his 50s, experienced in the slow machinery of law enforcement, aware of the currents moving beneath the surface. He faced the cameras and did something that was rare in police departments. He told the truth about institutional failure. Officer Derek Mason's actions do not reflect the values of this department or this community, Patterson said. His voice was steady. His words were official. We are recommending immediate termination of his employment and cooperation with federal prosecutors regarding potential civil rights violations. We are also implementing the following reforms effective immediately. Mandatory bias training for all officers. Installation of dash cameras in all units. Establishment of a community review board with subpoena power. Quarterly audits of traffic stop data sorted by race. And suspension without pay for any officer whose traffic stop patterns exceed statistical benchmarks for stops of minorities. The reforms were comprehensive. They were also something that should have been implemented 6 years ago, 7 years ago, 9 years ago. At any point in the chain of ignored complaints that had allowed Mason to continue. Internal affairs investigators continued pulling data. They found that Mason was not alone. 12 other officers showed similar patterns. 12 officers whose traffic stops targeted minorities at rates 2 to 3 times higher than their colleagues. 12 officers whose records were protected by the same system that protected Mason. The investigation expanded beyond the police department. It reached the towing company that had benefited from Mason's stops. Metro Towing had contracted with the city to provide towing services. Mason had called them at a rate significantly higher than other officers. The company had towed vehicles from people Mason had stopped at roughly 6 to 8 times per week, depending on how busy he'd been. When investigators looked at the financial records, they found kickback payments, payments to officers, payments disguised as administrative fees and consulting costs and other euphemisms for what was actually corruption. The financial trail ran deep. Metro Towing's owner had connections to city officials. Those connections led to contracts, to privileges, to a system where police enforcement became a profit center for a private company. Federal prosecutors announced charges, not just against Mason, against 3 other officers, against the towing company owner, against a system that had operated in plain sight for years. 18 U.S.C. Section 242, civil rights violation under color of law, false imprisonment, misconduct under color of law. The charges were serious. The prison time was serious, up to 10 years, maybe more. But there was a legal question that had to be settled first. Mason's attorney filed a motion to dismiss. The argument was simple and had worked before. One traffic stop, even if improper, doesn't constitute a federal crime. People get stopped illegally all the time. Are we really going to criminalize routine police work? It was a good argument. It was a dangerous argument. It was the kind of argument that had protected officers for decades because the courts had to decide. At what point does abuse become crime? The motion went to federal court. It went to Judge Harold Chen, a senior judge who'd spent 30 years overseeing civil rights cases. Judge Chen was known for careful analysis and precise application of law. He was not someone who could be rushed or pressured. He was someone who understood that the answer to this question would echo through every police department in the country. Richardson watched the legal proceedings from his chambers. He watched the defense attorney argue that federal overreach was the real problem, that expanding civil rights law beyond its traditional bounds would criminalize normal police work, that the system itself was on trial if you convicted an officer for what amounted to a single improper stop. And Richardson understood something about the moment. He understood that Judge Chen had to decide not just whether Mason was guilty, but whether the system had the courage to acknowledge its own failures. On a Friday afternoon, 3 weeks after Richardson's stop, Judge Chen delivered his ruling from the bench. The deprivation of rights through unlawful detention, even if temporary, is itself a violation. Officer Mason detained this individual without lawful cause. He conducted a search without probable cause. He created false accusations to justify the stop. The detention itself is the injury. The violation itself is the crime. The motion to dismiss is denied. The ruling made legal history. It clarified something that had been ambiguous in civil rights law for decades. A temporary stop, if unlawful, could constitute a federal crime. The detention was the damage. The violation was the harm. This opened the door to federal prosecution of thousands of cases that had previously been dismissed as insufficient. Mason's trial was set for 3 months away. The prosecution would have time to prepare. The defense would have time to strategize. The public would have time to understand what was at stake. The 3 months between Judge Chen's ruling and the trial were a period of institutional reckoning that extended far beyond Mason. Police departments across Georgia began examining their own traffic stop data. What they found was uncomfortable. Patterns, targeting, disparities that couldn't be explained by legitimate police work. Other victims began coming forward. Women who had been stopped without cause in the same neighborhoods at the same times by the same pattern of officers. 23 women in total. 23 individual stories of violation. 23 experiences of powerlessness in the face of authority that knew it would be protected. One woman named Renee Caldwell was a corporate accountant with a master's degree in finance. She'd been stopped 3 times in 18 months by officers in Mason's unit, each time on the same street each time for violations that upon investigation proved false. Her daughter, who was 8 years old at the time of the first stop, had nightmares afterward. The child had asked her mother, "Why did they hurt you? What did you do wrong?" And Renee had struggled to answer because her daughter was right. She had done nothing wrong. Another woman, LaToya Johnson, had been pulled over on her way to pick up her son from school, a stop that lasted 40 minutes. Her son waited at the schoolyard. Teachers called her emergency contacts. By the time she was released with a warning about a violation that had never actually occurred, her son had already experienced the terror of being alone, of waiting, of not understanding where his mother was. These stories accumulated. These testimonies gathered weight. By the time the trial began, the public understanding of what had happened had shifted from one officer to one system. The city council announced hearings. They invited Richardson to testify. They invited the victims to speak. They invited the police chief to explain the institutional failures that had allowed this situation to develop and persist. Richardson's testimony was measured and precise. He didn't speak about his own violation. He spoke about the data. 847 stops, 67% targeting black drivers, the mathematics of discrimination, the statistical impossibility of innocence. Chief Patterson's testimony was different. He acknowledged that the system had failed. He acknowledged that Mason should have been removed years before. He acknowledged that procedures designed to protect officers had instead protected corruption. This officer should have been terminated after the first complaint, Patterson said. We failed. We chose process over accountability. We chose protection of our own over service to the community. The admission hung in the chamber. It was the first time a police leader had named institutional failure so directly. The prosecution's case was built on evidence that was difficult to contradict. Body camera footage showed Mason's hand on his weapon while Richardson sat helpless in a wheelchair. Dash camera footage from other officers' vehicles, since Mason's wasn't recording, showed the stop beginning without any traffic violation preceding it. Dispatch records showed the backup call requesting units for a potentially hostile 10 to 15, creating a false narrative of danger. Statistical analysis showed the pattern of targeting across 6 years and 847 stops. Officer Edwards testified. The young officer, the one who had questioned the narrative in the first moment, took the stand and described Mason's visible anger at seeing a black driver in an expensive car. Edwards described the false accusations. Edwards described the escalation that had nothing to do with traffic safety and everything to do with the color of Richardson's skin. Richardson himself testified. His testimony was not emotional. It was factual. He explained constitutional law in terms a jury could understand. He explained what his rights were. He explained what had happened when those rights were violated. He was not angry in his testimony. He was not seeking revenge. He was simply explaining in the calm voice of a federal judge what the law said and what had occurred. The defense was built on a different foundation. Mason's attorney didn't deny what had happened. Instead, he argued about what it meant. One traffic stop, the attorney said to the jury, even if improper, even if motivated by bias. Is one traffic stop really a federal crime? Are we going to criminalize routine police work? It was the same argument that had protected officers before. It was the argument that mistook a temporary detention for something too minor to prosecute. It was the argument that had allowed problems to accumulate into patterns into corruption. The jury deliberated for 2 days. 2 days of weighing evidence, 2 days of considering whether the defense's argument had merit, 2 days of deciding whether a temporary detention, even an unjustified one, constituted a federal crime. The verdict came back on a Friday afternoon. The courtroom was full. Media cameras lined the back. The city was watching. The nation was watching. Guilty on federal civil rights violation, guilty on misconduct under color of law, not guilty on false imprisonment. The charge was complex. The jury had been careful. They'd acquitted on that count to show they weren't rubber stamping the prosecution's case. But the two guilty verdicts were enough. More than enough. The legal question that had hung over civil rights prosecutions for decades had been answered. A temporary detention, if unlawful and based on the deprivation of constitutional rights, could be a federal crime. Mason's face showed the understanding of what had just happened. His career was over. His freedom was at risk. There was no coming back from this. The sentencing hearing arrived on a clear morning in October, the same courtroom. The same gallery, now packed with people who wanted to witness what came next. Judge Harold Chen took the bench. Mason stood before him no longer in uniform, no longer carrying the authority of a badge. He was just a man who had been convicted of federal crimes. The prosecutor outlined the case one more time. The defense attorney requested leniency, pointing to Mason's 12 years of service, his family, his lack of prior convictions. Though the argument was difficult to make when the entire trial had been about his 6 years of targeted stops. Judge Chen was precise in his sentencing. He looked at Mason directly. "Officer Mason, you violated the oath you took when you put on that badge. You violated the trust placed in you by this community. You violated the constitutional rights of the individual before you. You did this not once, but as part of a pattern spanning 6 years and 847 traffic stops. The evidence presented in this trial suggests this was deliberate, systematic, and motivated by racial bias. I'm sentencing you to 7 years in federal prison, followed by 3 years of supervised release. During your supervised release, you will be required to complete civil rights training and perform community service in the neighborhoods that you targeted." The gavel came down. The sound echoed through the courtroom. The conviction was final. The sentence was imposed. The system, for once, had actually worked. Outside the courthouse, Richardson spoke briefly to reporters. "This case isn't about me," he said. "It's about accountability. It's about whether we're willing to enforce the law equally." Officer Mason believed he could do whatever he wanted because the system had protected him for 6 years. Today, that changed. But only because we insisted on it. That's the work that needs to happen everywhere. His words were measured. They were not triumphant. They acknowledged something fundamental. One verdict doesn't fix a system. One conviction doesn't change a culture. Within weeks, the police department's reforms were implemented with federal oversight. Mandatory bias training for all officers. Body cameras in all units with footage made public within 72 hours. A civilian review board with actual subpoena power. Quarterly audits of traffic stop data. Any officer whose traffic stop patterns exceeded statistical benchmarks for targeting minorities would face automatic investigation. The other 12 officers who'd been identified with similar patterns faced investigation. 3 faced criminal charges. 2 resigned before charges could be filed. 1 fought termination and lost in arbitration. Metro Towing lost its city contract. Civil suits were filed by the 23 women who had been stopped. Financial settlements began being paid out. Not as justice exactly, but as compensation for harm caused. Federal prosecutors announced that other police departments across Georgia would be examined. If the pattern that had been hidden in plain sight in one department existed in others, they would face the same scrutiny. The investigation was no longer limited to Mason or even to the police department where he'd worked. It had become something larger. Richardson established the Civil Rights and Law Enforcement Center at Emory Law School. His goal was to train the next generation of police officers and prosecutors to recognize bias, to understand constitutional law in ways that prevented violations, to build systems that protected rights rather than protected officers who violated those rights. The center's first curriculum was built around the Mason case. Officers studied the 847 stops. They studied the patterns. They studied the financial kickbacks. They studied what had been protected and why. They studied what it took to finally hold someone accountable. 18 months after the trial, more than 200 officers had completed the training. The curriculum was spreading to other departments. The case had become a teaching tool for what failure looked like and what accountability could achieve, but Richardson was careful never to declare victory. He understood something about systems that most people didn't. He understood that one conviction doesn't fix a system designed to protect itself. One verdict doesn't change a culture built on unquestioned authority. One officer's prosecution doesn't protect the thousands who will be stopped tomorrow. 6 months after Mason's sentencing, Richardson was driving home from the courthouse on the same route he'd driven thousands of times. A young black man in a modest sedan was pulled over by a different officer on Peachtree Road. Richardson stopped his car. He walked back to the scene. When the officer asked for his identification, Richardson didn't reveal who he was. He simply said, "I'm documenting this. I recorded your stop. If you pull over citizens without cause, that becomes a federal crime now. I hope you're familiar with United States versus Mason." The officer's face went white. She understood immediately that she was being watched, that the rules had changed, that there were consequences now. Later that week, the officer's supervisor sent Richardson a thank you note. The officer had been following up on a vague tip about suspicious activity in the neighborhood. The supervisor was grateful for the clarification about what constituted reasonable suspicion versus racial profiling. Richardson framed the letter in his office at the courthouse. Not as a trophy, as a reminder. The work wasn't finished. It would never be finished. Accountability was a process, not an event. It required constant vigilance. It required people paying attention. It required people refusing to accept that this is how things are, when how things are was fundamentally unjust. Years passed. Mason served his sentence. He was released after 6 years with time off for good behavior. He moved to another state. He didn't seek employment in law enforcement again. The reforms that had been implemented in the police department persisted. The culture didn't change overnight. Culture never does. But the incentives had changed. Officers who targeted people based on race faced investigation. Officers who conducted searches without probable cause faced discipline. The system began slowly to hold itself accountable. The Civil Rights in Law Enforcement Center grew. Its programs were adopted by police departments across the South. The Mason case was taught in law schools nationwide. Federal judges cited his conviction when sentencing other officers accused of civil rights violations. Richardson continued his work on the bench. He presided over cases, made decisions, wrote opinions that became precedent. But more importantly, he understood something that didn't make headlines. One conviction doesn't fix a system. In the neighborhoods where Mason had conducted those 847 stops, the pattern of over-policing didn't end when he was convicted. New officers arrived, different names, different faces. But the fundamental problem persisted. Some neighborhoods were policed with suspicion, with aggression, with the assumption of criminality that came from centuries of institutional racism. Richardson never stopped paying attention. He watched the data. He studied the patterns. When he saw new officers developing similar patterns, he documented them. When he saw the system beginning to protect them, he pushed back. One afternoon, driving home, he saw a family being pulled over. A father, a mother, 2 children. The traffic stop had taken 40 minutes. No violation was found. The family was released with a warning about something that had never happened. Richardson stopped his car. He waited until they'd driven away. Then he called the officer's supervisor and described what he'd witnessed. The supervisor was defensive at first, until Richardson explained that he'd recorded the stop, that he had time, that he was watching. The supervisor understood. The rules had changed. It wasn't victory. It wasn't justice in any pure sense. It was accountability, partial and imperfect, but real. It was the system being forced to acknowledge its failures because someone was paying attention. It was the price of power being raised just enough to matter. Years later, Richardson was asked to speak at a law school about the Mason case. Students wanted to know what had changed. What difference had one conviction made? One conviction doesn't change a system, Richardson said. He didn't sound discouraged. He sounded clear-eyed. One verdict doesn't change a culture. One officer's prosecution doesn't protect the thousands who will be stopped tomorrow. It requires each of us to pay attention. The real question isn't what happened to Mason. He went to prison. Justice was served in that narrow sense. But the real question is this: are you paying attention? What patterns are you noticing? What will you do when you see injustice? Because the only thing stopping these patterns is people who refuse to look away. The students understood. They were the next generation. They would become the officers, prosecutors, judges, civil rights attorneys who would face these questions. They would either perpetuate the system or change it. Their choices mattered. Richardson never claimed his story had happy endings. Mason was convicted, but other officers remained on patrol. Police reforms were implemented, but racial profiling continued in different forms. Victims received compensation, but their trauma remained. The system acknowledged its failures, but it was still the same system. What had changed was the cost of corruption. What had changed was the presence of witnesses. What had changed was the knowledge that someone was paying attention. In the quiet of his chambers, Richardson would sometimes look at the documents from the Mason case. 847 stops, 23 victims, 1 conviction, 47 police officers previously convicted in his career. And still the work continued. The work would always continue. Years later, when asked if he felt like his work had made a difference, Richardson was honest. "I've convicted 47 police officers in 23 years, he said. That's a number that should horrify you. It's a number that tells you how pervasive the problem is. But it's also a number that tells you change is possible if you're willing to demand it." The Mason case wasn't special because it involved a federal judge. It was special because people paid attention. The system didn't want to act. It took neighbors recording. It took a young officer questioning the narrative. It took federal prosecutors pushing back against institutional protection. The lesson isn't that one case changed everything. The lesson is that accountability requires constant attention. It requires people refusing to accept that's just how it is when how it is fundamentally unfair. If this story meant something to you, remember it. Remember the 847 stops that came before the one that was documented. Remember the victims whose cases never reached trial. Remember the neighborhoods where this pattern continues because nobody is paying attention yet. Pay attention. Document injustice. Refuse to look away. Subscribe to our channel for more stories about power accountability and what happens when systems are finally forced to acknowledge their failures. Because the only thing that stops patterns of injustice is people who refuse to accept them.